that, let's get smarter with the help of our leadoff panel, former U.S. Attorney Joyce Vance, who has spent 25 years as a federal prosecutor. She's a professor at the University of Alabama School of Law and co-host of the podcast #SistersInLaw. Neal Katyal, Department of Justice veteran, former acting Solicitor General during the Obama administration, who has argued dozens of cases before the U.S. Supreme Court. And Politico's White House correspondent, Eugene Daniels. Neal, here is some of what committee member Zoe Lofgren said on this network about money being used to pay witnesses. Take a listen.
We know that large amounts of money have been spent out of the fund that was amassed by the former president and is being used to pay for lawyers to various witnesses. The potential for coercion in that case is pretty obvious.
The potential for coercion. What does the committee, Neal, need to prove coercion, and could they already have that?
I'll be very quick because I think Joyce will be better on this than me. But the one thing I'd say is it's not illegal to pay money, pay someone's legal expenses. Corporations do it all the time, but so too does the mob. And the question is this kind of money being used the way the mob uses it in order to induce a certain story and a certain cooperation between Trump and these witnesses, or is it being done for legitimate reasons? And, you know, if this were someone who wore a goody two-shoes, it'd be one thing. It's Donald Trump, who we all know colors outside any sort of boundaries of the law. And so it does look really suspicious. I'm glad to see Liz Cheney says she's looking at it and that she expects the Justice Department to be looking at it too.
Joyce, I love whenever an ex answering a question, then they would. Your thoughts?
Who I always had to take my cases to for approval, DOJ. So I think the right line to draw is this. The funding issue is interesting. It has a lot to do with the ethical obligations that lawyers have to their clients. But when we're talking about witness intimidation, any effort, it doesn't have to be successful. It can be an attempt to hinder, to delay, to prevent a witness from testifying truthfully. That falls within this statute that reaches very broadly and gives prosecutors the ability to indict folks who engage in witness tampering. And the reason that this law is so important, I think, is pretty self-evident. It's because our entire criminal justice system is based on prosecutors' ability to get to the truth, to find out what the truth is, to prosecute wrongdoers. And if you have someone who's engaged in wrongdoing, but who's keeping evidence of it out of the hands of prosecutors, you've got to treat that very significantly, very strenuously. You know, we like to always say, I think, in the wake of Watergate, that it's the cover-up, right? It's always the cover-up that gets people in trouble. Witness tampering is the cover-up. And so if that evidence comes to light, I'd look for DOJ to go after it pretty hard.
Let me ask you another question about this, Joyce, because earlier today we heard from another former White House aide who is friends with Cassidy Hutchinson. Take a listen.
Trump world was assigning lawyers to a lot of these staffers who themselves, you know, don't have big
assigning lawyers.
Well, I should say covering the cost of lawyers for people who don't have big legal defense funds to themselves.
So they were paying Cassidy Hutchinson's lawyer?
Is my understanding. You'd have to confirm that, but she had someone, Stephen Positano, who'd been in the White House counsel's office, is still aligned with Trump world.
Okay, here's what's interesting to me. That former aide says Hutchinson changed lawyers when she decided she had more to tell the committee. Could the argument then, Joyce, be made that the Trump lawyer was trying to contain Hutchinson's testimony?
It depends on what the facts are here. It's not uncommon to see a third person paying for someone's criminal defense, you know, but we see it all the time. Neal points out mob cases, also in drug trafficking cases, in the cartel linked drug trafficking cases. It's not unusual to see that sort of situation come up. And it is technically acceptable so long as the lawyer is representing his client and not the person who's paying him. And that's where we have this, I don't think it's a bright line distinction here, but it's possible that you could have a lawyer who could cross over that line so far that he wouldn't just be failing to vigorously represent his client, to zealously represent his client. He might also find himself caught up in some form of a conspiracy to intimidate the witness.
Eugene,
but we won't know that until we know more about the facts.
I apologize there, Joyce. Eugene, I don't need to tell you, President Biden has so far been silent on the January 6th committee's activities, but NBC reports he intends to give a speech once the investigation is over. He will, quote, emphasize what Biden believes is at stake should former President Donald Trump or his allies return to power in Washington. Draw on revelations from the committee's investigation to make a vivid case against voting for Republican candidates in November. Is this seen, Eugene, as a shift in strategy in terms of how the current president responds to all of this?
I think from the very beginning, what they wanted to do is that the committee kind of do its work, right? They didn't want, and we reported this in Politico, they didn't want President Biden to be out front talking about what was happening every single day. You weren't going to see tweets from his account. You weren't going to see him on TikTok talking about it. That wasn't going to be their strategy. And you weren't going to see aides on background kind of giving a sense of how the White House is viewing that. Because one of the reasons that we're in this position having this committee is because of how Donald Trump used and talked about law and, most importantly, his Justice Department. And so there's an investigation happening right now behind the scenes with Biden's Justice Department, and he doesn't want to be in any way seen as putting his thumb on the scale. So this would be seen as a bit of a change in strategy. He's going to be careful here, though, and I think that people shouldn't expect him to go out and, for every single big moment that we've seen in these committee hearings, go through every single one of those. He has constantly talked about what happened on January 6th as a dark day for democracy, and talked about how he sees Donald Trump and his allies as dangerous for democracy. That sounds kind of in line with what we're going to see if we see him after the January 6th committee. You aren't going to see him tell Merrick Garland in front of the American people to go get them and arrest them, because he doesn't want to be seen as, and doesn't want to tell Merrick Garland or the Department of Justice what to do, no matter how much pressure the left has been putting on Merrick Garland or has been putting on Joe Biden to put on Merrick Garland. And so folks who are getting, I think, kind of excited about seeing Donald Trump see Joe Biden really take Donald Trump to task because of January 6th and the revelations. On the aspects where there's possible culpability, criminal culpability for Donald Trump and some of his allies, I think that this White House is going to continue to steer clear from there.
Neal, speaking of dangers to democracy, this court has decided to take up this issue of state legislatures and federal elections. Dave Wasserman of Cook Political Report tweeted, hard to overstate what a radical step this would be, given that many swing state legislatures are gerrymandered in ways that self-perpetuate GOP control, would decimate checks and balances. I wonder, Neal, what you make of the court's decision to take this case.
Well, this case is the North Carolina redistricting case. It's my case, actually. So I'm, just going to be pretty silent on this, except to say that I am very worried about the U.S. Supreme Court at this point. I mean, it's my lifeblood. I've argued there 45 times. I love the court. I revere the court. But this particular composition of the court is the most conservative, extreme court in our lifetimes. It's one of the three most conservative courts ever. Only 1857 and 1935 come close. And you know what happened after both of those years. So I'm optimistic about this particular case because I think the history is so much on our side. But I do think, as we think about like what happened today with the greenhouse gas emissions case, what happened last week with abortion and with guns, what's happened, for months about the religion cases, this is a court that is out of step with the mainstream of American society right now and entrenching a certain view of the law and politics into our United States reports. And it is a worrisome trend.
And Joyce, for years, Republicans have accused Democrats of trying to appoint activist judges. You now have critics arguing that that is what they are witnessing from these 6 conservative justices. Your thoughts?
If what we've seen this term is not judicial activism, I don't know what is. This is a court that has used textualism in so many cases claiming that they have to find the founding fathers' intent and using that to do absolutely insane things like permit people to have AR-15s in public in this country in the midst of a wave of gun violence. But by the same token, when textualism does not serve this court, they don't feel constrained by principle. And so we see the decision that we saw today in the EPA case, where they used something called the major questions doctrine, very rarely used, to say that Congress hadn't given the EPA sufficient authority, hadn't been explicit enough in that grant of authority to permit the EPA to take important steps to slow the advance of climate change. And it's amazing when you think that we've seen that same doctrine, very rarely used in our nation's history, used a couple of other times by this court, in one case to end the nationwide ban on evictions during the pandemic, and in another to keep Joe Biden from requiring vaccination at large companies. So this is a court that's been very facile about how it's used doctrine. It's not a good look. It's very disheartening to people like Neal and like me who love the court and love the law, because we understand that at the core of the court's authority is its integrity. It doesn't have an army to go out and enforce its orders. Its orders and the rule of law work in this country because we have confidence in them. The Chief Justice will have his work cut out over the summer recess to try to return the court to some sort of moral center.
Right, and while he is, please jump in, Neal.
I was just going to jump in because I think Joyce is absolutely right. The way the Supreme Court acted today by basically ending a lot of greenhouse gas regulation was to say this major questions doctrine applied. The idea, they said, was that Congress had to specifically give the EPA authority to regulate in this area. And I guess calling it the Environmental Protection Agency left some ambiguity as to what the agency was designed to protect. And Justice Kagan, I thought, in her dissent today was absolutely spot on when she said, well, I guess I've been a little hasty in concluding that we're all textualists now. Because when it came to the text and authorization of the Environmental Protection Agency, the conservatives on the court just blew past it. That's why I think, what's so worrisome here is that it looks like an abandonment of principle for a results-oriented jurisprudence. And I think Joyce is right to call this as activist a court as we've ever seen in our lifetimes.
Eugene Daniels, Joyce Vance, Neal Katyal, thank you all so much for getting us started.